So it happened, you filed an eviction, but your tenant filed an eviction appeal. Now what do? We're talking all about eviction appeals today. Let's get started. I know it can be frustrating. The whole process is a frustrating endeavor. You're in the eviction court because in your mind, the tenant has done something wrong, and now they're gonna get a second bite of the apple when in your mind, this should have gotten wrapped up a long time ago. Believe me, I totally get it. Now, for those of you who are in Texas, I've come up with a do-it-yourself course on eviction. It takes you from start to finish. It's literally called Texas Eviction, step-by-step from start to finish. You go from the original notice all the way through judgment, and it even includes what to do in an eviction appeal. If you're interested, type attorneyeg.com/EV and you'll get all the information you need. www.attorneyeg.com/EV. The address is on the screen. You'll find a link in the description. So one thing you need to do absolutely is understand that the rules are a little bit different now that the appeal has been filed. By understanding these differences, you're likely going to be ready when something goes wrong. But you're probably thinking to yourself, how could I possibly understand every single thing that could go wrong or every step that I need to take? I agree, there's a lot here. And so if it comes down to you absolutely needing to get an attorney, go ahead and do that. If this is your first eviction appeal, you might feel a little more comfortable finding legal counsel in your jurisdiction that can help you through the eviction process. Now, I practice in the state of Texas, and I'm happy to help any of you throughout the state of Texas. But for all the rest of you who are thinking, you know what, I think I'd like to try this one on my own, I'm gonna give you some practical tips that you can follow to get through your eviction appeal. So one thing you might be asking yourself is, why does my tenant have the right to file an appeal in the first place? I don't understand that. Well, it comes down to basic equity. First off, it is very likely that wherever you are in the United States, that your tenant has a right as a matter of state law to file an appeal no matter what happened in the first procedure. If that's the case, then it doesn't matter just how solid a case you had against them. It probably doesn't even matter that they didn't show up to the original eviction trial. The fact is, as a matter of right, they get one appeal, then it shouldn't come as a shock when they do file it. Now, the truth is, most tenants do not file appeals. So I practice in Houston, and in this jurisdiction, generally speaking, about 80% of evictions come and go in the justice court. They start and finish in that first procedural step and never pop up again. The landlord recovers possession pretty quickly, usually within about 30 to 45 days here in Houston, and the process ends. But 1 out of 5 of them do file an appeal, and those cases do move on. And in those cases, I tend to get phone calls from landlords saying, I don't know what to do, please help me. And that's what this video is all about. So if you find yourself in a situation where your tenant has filed an eviction appeal, it's not because you did anything wrong. It likely has more to do with the fact that as a matter of right, they're entitled to it. An appeal does not in and of itself mean you had some kind of problem with your underlying case. It just means that the tenant is exercising a right that most tenants have. Now, another question you might be asking is, does my tenant still have an obligation to pay rent during the eviction process if they filed an appeal? Well, the simple thing to ask is, are they still in possession? If they're in possession and they haven't paid rent, then definitely they're going to continue to owe you rent as long as you and they have a valid rental agreement. Of course, if they never owed you rent in the first place, filing the appeal doesn't suddenly make rent owed. But if your underlying case is about unpaid rent, or even if it's a non-rent matter, the obligation to pay rent continues so long as the tenant is in possession. Now, technically, they may have a rent obligation owed to you even after they vacate the property, but for purposes of eviction, if they stay, they gotta pay. What about that eviction judgment? Now that I won in the lower court, can't I just move forward with it? I got unpaid rent, I got a right to possession. Why can't I just use that and get possession back? Well, the simple answer is, by virtue of the appeal, that judgment's gone. don't believe for a second that you still have a winning judgment. That's what an appeal is. It essentially says the lower court's finding no longer exists. We're moving on from that. In the state of Texas, what you get is an appeal de novo, which means you're just going to start the whole thing over. You're going to get a brand new trial as if it had been filed in the higher court. The lower court's finding is absolutely irrelevant. You cannot use it as evidence in the subsequent trial. You essentially present your whole case to the new court on the eviction level. So that judgment is gone. So what are some of the key differences between the original eviction court and now the matter on appeal? Well, among them are some procedural differences. For example, if rent is to be paid into the court's registry, that's usually not something that happens in the lower eviction court. In the state of Texas, there might be a requirement, it's not 100%, but it happens a lot. There might be a requirement for the tenant to pay rent into the court's registry during the pendency of that appeal. If in your jurisdiction there's a requirement for the tenant to continue to pay rent in this way, you're going to want to know what the process is of that payment and what happens at the end. Is this money that you get? Is it automatic? Do you have to file a separate motion or include it in a particular order? These are things you're going to need to find out because it's different than it was in the original trial setting. The appeal comes with other procedural differences, including how things are handled in that court. You may be having to do things that are different than you had to in the original trial court. One of the big things has to do with evidence. You maybe didn't have to present exhibits in the trial court. In fact, you might not even have been asked about any of your evidence in the original trial court. But chances are on appeal, you may be required to present evidence in a formal way. You may be required to submit copies of your evidence ahead of the trial setting. You might have to label your evidence and submit it and know how to enter it into the court's record. If you are unfamiliar with these things, it may be very helpful for you to contact counsel to either get an idea of how to do it properly or to have them do it for you. The presentation of your eviction appeal might also have formalities that just aren't present in the lower court. Among them is the drafting of motions and orders. Many of the lower courts in eviction have very little requirement of the landlord in terms of these kinds of processes. But on appeal, you may be held to a standard that's higher than that lower court does. And you may be asked to produce your own motions and your own orders. In fact, if you don't have them ready in time for trial, you might get your case reset. Make sure that you've contacted the court and you are aware of these procedural differences that may be required of you even ahead of the trial setting. Call ahead, find out. You're probably going to receive things in the mail or notice by email indicating to you these differences, possibly a higher set of requirements from you to take care of ahead of your trial setting. Additionally, it's very common for timetables to be different. The procedures in the lower court may be different than those on appeal in your eviction. There might be a longer time to file another appeal. There might be a longer time before you're able to get certain instruments like a writ of possession or an abstract of judgment. These differences are important and you may want to know so that you don't take unnecessary trips or file something that is improper. You'll want to know ahead of schedule. Do you do things on the same timetable as the lower court? If not, on what date may I do the following? Whether it's a writ or the abstract of a judgment or when a judgment is signed. And then the really big question that involves guys like me is, do I really need an attorney if my tenant has filed an eviction appeal? Come on, of course I'm gonna say yes. The truth is, you might not need an attorney. Definitely in the state of Texas, there are certain procedures on an eviction appeal that don't require an attorney at all. It might be helpful if, again, you're unfamiliar with the process and you'd really like some guidance to make sure you're covering all your bases. But for the most part, the eviction process in the state of Texas is carved out in a way where, even a registered entity like a corporation or an LLC can show up to most trials, not all of them, but can show up to most eviction trials and present a full case without an attorney present. Now, naturally, I'm going to suggest that consulting with an attorney before you take these steps is probably a good idea. So don't just show up and hope for the best. Maybe set a consultation well ahead of schedule, ask your questions, and make sure that you've taken care of everything you need to procedurally, and that if it does turn out things are probably a little more complicated than you are comfortable with, you have time then to hire counsel so that they can proceed with your case now in the eviction court. I hope you found today's video especially helpful. Comment below if you have a question for me. Give us a like, and if you haven't subscribed yet, please consider subscribing. Eviction appeals can be a little intimidating. It's okay to ask for help. In fact, it's recommended if you've never gone through an eviction appeal, no matter how many cases you've taken to the lower eviction court. If you've never done an eviction appeal, you're going to want to ask around and get information to make sure you're on track for success. But wherever you are in your eviction journey, if you've got questions, there are answers right here on this channel. YouTube seems to think that this video right here is the next best thing set up for you to watch. Enjoy it and all the rest of the content on this channel. And until next time, landlords, happy leasing.